The Honorable Presiding Chief Judge and Judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Thank you, Mr. Horn. Good morning and welcome to the WebEx session of the North Carolina Court of Appeals. Today, we have one case on the calendar for hearing, in re R.D.B. And your panel, as you have already been introduced to, is myself, Linda McGee, Judge Valerie Zachary, and Judge Hampson. We are pleased to be with you today. And we are ready to proceed with the oral argument. Is the petitioner ready?
You're muted. Yes, Your Honor.
And please introduce yourself, since we seem to have some changing characters today.
Yes, Your Honor. My name is John Burns, and I'm here with Preston Odom, and we represent petitioners appellants.
Thank you. You may proceed.
May it please the court. Your Honor, we would like to reserve 5 minutes for rebuttal. We do represent petitioners appellants Ruby and Caleb Harkness in this case. As the court is aware, this case arises from the appeal of a guardianship award by a Mecklenburg County Clerk of Superior Court after a trial that lasted about 6 days. That award was appealed to the Superior Court Division of the Mecklenburg County Court. It was appealed pursuant to NCGS 1-301.3D. We had a hearing in front of the Honorable Carla Archie, after which she entered an order affirming the guardianship award, and we have timely appealed to this court. We present various errors on appeal that we believe the court should find as constituting reversible error, and we ask that both the guardianship, well, we ask first that the order affirming the guardianship award be vacated and that the matter be remanded for further proceedings. With regard to our first issue, and we believe that it's a novel issue and a threshold issue, we contend that the rules of evidence should have applied to the proceeding before the Mecklenburg County Clerk of Superior Court. The statute that would govern whether or not the rules of evidence apply, there are actually several statutes. The first and most obvious is North Carolina General Statutes 35A-1223, which governs whether or not the hearing before the clerk is a formal hearing and what evidence ostensibly can be accepted in that hearing. The other statutes that apply would be, first and foremost, the Rule 101, scope of the rules from 8C-1, our rules of evidence, Rule 1101A, which is 8C-1, our rules of evidence, and then the appellate statute itself, the statute that provides that the award is appealed on a limited basis to the Superior Court. That also, we respectfully contend, dictates that the rules of evidence should apply even at the trial level before the clerk.
Excuse me, Mr. Burns.
Yes.
Are there any examples where this court has held that the rules of evidence don't apply in this type of case in the absence of a specific statutory exception?
With regard to this type of case in particular, I'm unaware that there is any case law that holds that the rules of evidence do not apply. I know that Appellate makes an argument that similar statutes have reached that result, but for various reasons we believe that this is a special case, and especially due to what I just said, 1-301.3D, the appellate framework that the Superior Court uses. We respectfully contend that the rules do apply, and that there is no precedent saying that they don't.
But in all the other cases, we've never held that the rules of evidence apply in the absence of a specific statutory exception, right?
Well, That's right. Rule 101 and Rule 1101 of the Rules of Evidence require that the Rules of Evidence apply to all proceedings except those specifically accepted by statute. And we would contend that this is not a proceeding that has been accepted by statute, and therefore that the rules should apply.
Thank you.
And the appellate statute 1-301.3D is really an important part of why it seems clear that under the statutory scheme itself, the rules of evidence should apply even at the level of trial before the clerk. Amongst other things, the Superior Court judge acting as an appellate court is required to evaluate whether or not the admission or exclusion of evidence in front of the clerk constituted prejudicial error. While 35A-1223 permits the hearing to be an informal hearing, we would respectfully contend that there's no real way that the Superior Court could determine whether, first of all, error occurred, and second of all, whether that error constituted prejudicial error, but through the lens of the rules of evidence. The statute, the appellate statute 1-301.3D also sheds light on the quote-unquote informal language that 35A-1223 uses. In particular, the appellate statute provides that there is no, that the litigants do not have to specifically make objections to either the admission or the exclusion of evidence during the procedure before the clerk in order to assign error on appeal that the Superior Court judge is to resolve by reviewing the record. And so when trying to determine what it means that the hearing could be informal, I think first 35A-1223 says that you can accept affidavits, which would make it less formal than a full-blown jury trial in front of using the formal rules of evidence. But it also, I think when the statutes are read together, the informality comes from the fact that specific objections aren't required to be lodged in order to preserve the arguments for appeal.
Is that the only meaning of informal in circumstance?
I'm sorry, Your Honor, I didn't understand you.
Is that the only meaning of informal under these circumstances?
Well, there have been previous appellate court cases that have reviewed a different statute, and Appellate brings one up in his brief. That would be the In Re J.H. case, which looked at 7B-901A. That same language, informal, is used in that statute, and there is the court does note in that case that the formal rules of evidence don't apply to that proceeding. That statute, though, is distinguishable from 35A-1223 in that it says more about whether or not the rules of evidence apply, and specifically it says that the court may consider hearsay evidence in it's a juvenile disposition hearing after an abuse neglect dependency adjudication, and it says that the court may consider hearsay evidence. That is not something that 35A-1223 says. So they both do use the word informal, but there are distinctions between what exactly informal means. We would respectfully contend that In Re J.H. isn't particularly applicable because given that the legislature knows how to say when it does not wish to apply the rules of evidence, including the rules of hearsay, it knows how to say that, and it has said that in other contexts that it didn't say in this context. That also goes for other statutes that were referenced in Appellate's brief, including the 45-21.16D that was analyzed in In Re Lux. In that case, the framework of that case is not similar to this case in general. But in that case, as well as 7B-1110, 7B-1110, the legislature also says specifically that the rules of hearsay do not apply, which it doesn't say here. So, a long-winded answer to your question, the court has reviewed what it means to be an informal hearing, but only in a different context, never in the context of this procedural history in particular.
And Mr. Burns, if I can jump in.
Yes, Your Honor.
Briefly, but isn't part of the concept here with this informal proceeding before the clerk, the clerk is ultimately trying to determine what's in the best interest of the minor. And so in that regard, is this not more of kind of an inquisitorial proceeding than it is an adversarial proceeding? And so isn't the concept here that the clerk should be able to gather all the information from the parties and the guardian ad litem, et cetera, that the clerk needs in order to make this fundamental decision, you know, kind of the best interest polar star inquiry to determine, you know, who should be the guardian of the person of this minor child?
Yes, Your Honor. I do believe that all of the applicable case law about best interest of the minor child and the fact that it's inquisitorial versus adversarial would apply in this context. But I would point out that, you know, in child custody cases, the rules of evidence apply. Even though it's more of an inquisitorial rather than adversarial case, in almost every courthouse in our state, in the domestic courthouse, objections to hearsay, relevance, more prejudicial than probative, objections to expert testimony are made and sustained. I would also say that 1-301.3D contemplates that there will be situations where evidence is admitted in error, and that constitutes prejudicial error. And so to say that because, and I'm not suggesting that this is precisely what the court has said, but to say that the informality language just permits the clerk to gather whatever evidence he or she wants to gather or believes is necessary, that would more or less preclude the Superior Court judge from being able to find that prejudicial error occurred from the admission of evidence, which the legislature clearly contemplates will happen.
Well, and then turning to the Superior Court order in this case, that I guess it's really both at record page 99. How do we square, on one hand, the trial court's legal conclusion that the rules of evidence did not apply before the clerk, what appears to be a slightly different analysis in, I think it's sort of findings 22 and 23, where it seems to be kind of reviewing the clerk's discretionary call on this evidence, weighing factors like the age of the child, the potential for kind of undue influence given the recent passing of the child's mother, nature of the proceedings. That seems sort of, those two concepts seem somewhat inconsistent. On one hand, it seems like the trial court is kind of doing this weighing analysis as to whether this evidence was admissible or not. On the other hand, it's saying the rule of evidence simply does not apply. Can we square those two different analyses?
Well, Your Honor, I think it's very difficult to do so, and which is one reason that I think that the rules of evidence should and do apply in this context. We can't be assured by reading the court's order that the Superior Court judge did apply the requisite appellate standard of review. There are comments that are made that attempt to address, because 1-301.3D allows the court to review the findings of fact, review the conclusions of law, confirm whether the findings of fact and conclusions of law support the ultimate award, but also require this analysis regarding the admission or exclusion of evidence. And so the court may be noting what it's maybe attempting to accomplish something else with those findings of fact, but ultimately it's difficult to know what standard of review the court applied. No, I'm sorry, I'm not sure that I answered your question. We believe that it does matter in this context, Your Honor, because for that very reason. When a superior court acting as an appellate court applies an incorrect standard of review, the order should be vacated and the matter should be remanded so that the correct standard of review applies. Also, more generally, final judgments, as is noted in our brief, final judgments that are based on a misapprehension of law should be vacated. So, to the extent that the court relies expressly on the conclusion that the rules of evidence don't apply, which is conclusion number 2, the court has conducted an improper analysis, and we respectfully request that the court should do so using the proper analysis. I would say, though, that if the court finds that the rules of evidence generally don't apply based on the statutory scheme, I don't believe that there's any question that they applied in this case, given the transcript and the various evidentiary rulings. To the extent that that's true, we would contend that they should be applied fairly and consistent with North Carolina law. I would point out that 35A-1223 does use the word may with regard to whether or not the hearing is formal or informal. It says that the court may conduct an informal hearing, which implies that the court may also conduct a formal hearing applying the formal rules of evidence, which is what the court, in ruling on various hearsay objections, more prejudicial than probative objections, leading objections even, has done in this case, and we would respectfully contend that for those reasons it applies here. Even if it doesn't apply here, 1-301.3D requires the court to review the record, review the transcript, and determine whether the admission or exclusion of evidence constitutes prejudicial error. And for the reasons that we set forth in our brief, we contend that whether or not the rules apply, the prejudicial error was committed in these cases, especially with regard to 3 important evidentiary rulings. First, the exclusion of statements that were made by the child to members of his family regarding his mental and emotional condition, his state of mind, his thoughts about where he wants to reside, whether with the petitioners or appellants or with the appellee, and what his feelings are when he is only with appellee while he resides in Charlotte. We contend that that was prejudicial error, excluding those statements. We further contend that the trial court impermissibly allowed all testimony regarding the minor child's deceased mother, regarding her intentions for the child, whether she wanted the child to be adopted and by whom, where she wanted the child to go to school, who she wanted to raise the child in the unfortunate event that she passed away, given that the child's biological father had already been deceased for several years.
So had the child's mother passed away, not intestate, but with a will wherein was expressed some desire for the child in the event of her death, would you concede that would present a different scenario given those testamentary statements?
Yes, Your Honor, absolutely. And in fact, there's a statute that expressly provides for that, 35A-1225, expressly says that when the parent's wishes for the child are reduced to a testamentary document, they can and should be considered in this guardianship proceeding. We would contend that is the appropriate way for those wishes to get before the court in a context like this. The way that it occurred in practice in the trial court was that, and for some of the reasons that the clerk attempted to exclude statements made by the child, which was she didn't necessarily want everybody to come in and testify, the child wants to be with me, the child wants to be with me. She allowed in any witness to come in and be interested in what the deceased mother may have said to him or her. And without conducting any prejudicial versus probative analysis or anything else. So effectively, witnesses were allowed to testify that she told me that she wants me to raise the child, or she told me that she wants me to adopt the child, which we also contend was error. Our third major evidentiary ruling that we contend is prejudicial error was that a grief counselor was permitted to testify as an expert, notwithstanding the fact that her testimony and her expert opinions do not meet the Daubert standard, and that she was allowed to opine about the facts and circumstances of this case, and in particular her opinion that the child shouldn't move and that nothing about the child's life should change, which she testified that she formed after only one 20-minute interview with the child. We contend that, she also came in response to the first question, are you here to give an expert opinion? She said that she did not think that she was there to give an expert opinion, but then was allowed to testify at length regarding what she believes is best for the child based on her conversation with the child. She was asked to confirm that her opinion that the child shouldn't move was based on one 20-minute interview, and she confirmed that. She was later asked, did you do any additional investigation regarding that subject, and she said that she didn't. She was told, she testified that she didn't have knowledge about a lot of important things that were at issue in the trial, including how long the child's bus ride was, because there was testimony that it was an hour or more, how the child's grades were. She hadn't spoken to anybody from the child's paternal biological family that were down in Atlanta, and all of which testified as witnesses in support of the petitioner's application for guardianship.
But at what point does that become a question of weight and credibility to be given to that evidence, and at what point does it become a question of admissibility?
Well, Your Honor, I think that it does need to meet the threshold Daubert standard to even be admissible. Thereafter, I do agree that a lot of expert testimony comes down to its weight rather than admissibility, but the reliability prong of Daubert in particular is offended by the foundation that was laid in this case. First and foremost, the therapist wasn't able to provide the court with any testing, with any notes from her therapy, with any scholarly articles that she relied on, with anything. She testified that only based on her clinical experience, quote unquote, she was competent to opine as she did at the hearing. Appellate points to several criminal cases where clinical experience has been held to be a sufficient foundation for expert testimony, but in both of those cases, the expert was only allowed to testify to general principles and not opine about the specific facts of this case. And so in its gatekeeper role, we do respectfully contend that the clerk should have considered whether or not the reliability prong was satisfied based on the very little testimony regarding the foundations for the opinion and the non-existent investigation thereafter.
Excuse me. My understanding, you're arguing that this was prejudicial to your client. How would you respond to the argument that it can hardly be prejudicial when the trial court barely mentioned it? The trial court, in the order, says that the child attended grief therapy, but doesn't really say anything about what her testimony was.
The order in general is an extremely close call, even as it's written. So the court makes various findings of fact that the Harknesses have a safe and appropriate home, that the Harknesses have a very strong bond with the child, that the Harknesses have been very proactive in the child's life, just as they do with Mr. Mann. So while the court didn't make a specific finding of fact that because the child told the counselor X, Y, or Z, there has to be some reason why Mr. Mann was chosen as a guardian over the Harknesses, given the other findings of fact. In deciding what is in the best interest of the child, sometimes that calls a court to decide between two very good options. The order doesn't give an explicit reason why Mr. Mann was chosen. It never says it would be in the best interest of the child for Mr. Mann to be its guardian. It has general language about what makes a good guardian and the fact that there shouldn't be two guardians, but it doesn't say Mr. Mann, it's in the child's best interest that Mr. Mann be the guardian. And so, as we've noted in our brief, I think that it's implicit, both for the fact that the child's wishes were never considered, as well as for the fact that the child's wishes as expressed to family members were never considered, as well as the fact that, the therapist testified to what she testified to. We're only left scratching our heads and wondering, did that tip the scales? Because it's not clear, but we believe that it did. We believe that that's why the error was prejudicial in this case. And may it please the court, I guess I'm to the time where I'd like to reserve for rebuttal. So thank you.
Yes, sir. Thank you. We'll hear from the appellee.
Thank you, and may it please the court. I'm Kip Nelson here on behalf of the appellee, Raymond Mann.
Hi.
Your Honors, the fundamental problem with the appellant's argument is that it's untethered from the context in which these decisions are made. In a guardianship proceeding, the clerk is not apportioning fault or determining liability or even deciding which version of facts is true. The clerk's role is to determine what outcome is in the best interest of the child. It's purely discretionary.
But Mr. Nelson, would you agree that there have to be some parameters on what should be considered, what is reliably considered in these proceedings, and just generally some basis then for the Superior Court to be able to review the decision that a clerk makes?
That's exactly right, Judge Hanson. As with any abuse of discretion standard, it's not a free pass for the appellee. It's a recognition of a deferential standard that gives deference to the fact finder or the decision maker's role. So certainly if I like to think of abuse of discretion as a realm of possible choices. And the question for an appellate court is it within that spectrum? If it's beyond that spectrum, then the court can say it's an abuse of discretion. But the role is not to reweigh the evidence or to decide whether the clerk made a good decision. It's simply whether it was within the realm of reasonable decisions.
But we look to the rule, even when we're reviewing discretionary evidentiary rulings, we look to the rules of evidence to kind of frame that analysis as to whether a trial court properly exercises discretion under a rule of evidence.
Well, sometimes, if the rules are applicable. But the rules themselves say they apply unless they don't. And so the briefs go through several instances where the General Assembly has said the rules are different, the rules are relaxed in certain circumstances. Here, Section 35A-1223 is a legislative determination that the guardianship hearing can be informal and that the clerk can hear whatever evidence she deems necessary to make the best interest determination. The appellants have not explained what that statute could mean other than a relaxation of the rules of evidence. And that statute makes sense. The very nature of a best interest analysis is holistic and complicated and looking at a variety of factors. And we defer to the decision maker who's familiar with the parties and the child to make that decision. We wouldn't want to enforce the strictures of the rules of evidence. In fact, that would be antithetical to the clerk's role. Again, the clerk is not like a traditional fact finder deciding who's right and who's wrong. The question is, how can I best serve the child? And that was the decision that was made here. So if the rules of evidence apply, Judge Hanson, then I agree that would be the proper framework But here, there's a specific statute that at least suggests, if not explicitly states, the rules don't apply. The statutory language is the clerk can consider whatever evidence she deems necessary. That's, again, providing discretion to the clerk, recognizing this unique role. Certainly, my friend on the other side is correct that the Superior Court's role then is to decide whether there was prejudicial error in that decision. That doesn't suddenly revive the rules of evidence. In other words, Section 1-301.3 doesn't negate the plain language of Section 35A-1223. And importantly, something that has not been brought up so far is Section 1-301.3 is not limited to guardianship proceedings. That is a general statute providing for a route of appeal from all clerk's decision in estate matters, whether it's incompetency or minors or other things. So there are, in fact, cases in which a superior court reviewing a clerk's decision under Section 1-301.3 would be looking at the rules of evidence. It's simply not the case here because of a specific statute on point. So, although I agree that Section 1-301.3 applies, again, it doesn't somehow trump the body of evidence that the General Assembly has said is appropriate for the clerk to consider. Here, the clerk heard from 17 witnesses over the course of 6 days and looked at the exhibits and heard the arguments of counsel, and based on all of that, determined that the child's best interest would be served by appointing Mr. Mann as his guardian. Now, the fact that appellants disagree with that decision does not constitute an abuse of discretion, particularly when that decision was consistent with both the district court's earlier custody order and the recommendation of the guardian ad litem. The clerk, after hearing all the evidence, decided that Mr. Mann was an appropriate guardian as the child's stepfather, with whom he has been living and taking care of for several years already. Going back to that analogy, that was a decision within the realm of reasonable decisions. Now, appellants have attempted to paint this as an evidentiary issue, as if it comes before this court after a jury trial. But again, that's not the context in which this case arose. Again, the best interest analysis is different and requires a different analysis. All of the appellant's arguments to this court are based on the formal rules of evidence. In other words, they have not made a general abuse of discretion argument or even an evidentiary argument separate from the rules. So if the rules don't apply, as the Superior Court determined, then this court should affirm and doesn't need to go any further. But if the court were to reach appellant's arguments, there are just a couple of things I wanted to address. First, Mr. Burns asserted regarding the wishes of the mother that the clerk did not conduct any sort of prejudicial probative analysis. And I would disagree. The clerk specifically said, I find that this information is helpful to me in making the determination. I want to know what the biological parents wanted for their child. To go back to one of your questions, Judge Hampson, there is a statute that provides for the role of a testamentary recommendation. I would disagree that that's the only way that a parent's wishes can be relevant. That certainly provides one avenue, but if a parent hasn't executed a will, that doesn't suddenly mean that the parent's wishes aren't relevant. And of course, as with all of these issues, none of the testimony is binding on the clerk, who again is taking a holistic view in determining best interests. So regardless of what various witnesses said about the mother's wishes, the clerk was not bound by any of that evidence. But importantly, the other issue about the mother's wish is appellants presented the same evidence on their side. So while there was some evidence that the mother had said she wanted the child to be raised by Mr. Mann, Mr. Harkness, one of the appellants, testified that the mother had said the same thing about the Harknesses. So it can't be prejudicial error for the clerk to hear evidence, conflicting evidence on the same point, and then to reach a decision on best interests.
How do you respond to the argument that even taking all this evidence from both sides, the clerk really failed to kind of make ultimate findings of fact determining, this best interest question between, two otherwise perfectly qualified parties to exercise guardianship over the minor child.
And sorry, it cut off on the end. So I think your question was, how do we address the failure to make ultimate findings of fact? And I think that goes to one of the discussion with Judge Zachary about the grief counselor too, because there were no findings of fact. Here, the clerk is not required to make, in your words, ultimate findings of fact. The statute lays out that the clerk may make findings about the assets and liabilities of the child, but the clerk could have entered an order that said, the assets are these, liabilities are these, in my discretion, I think the guardian should be X. That would have been sufficient for appellate review. The statute doesn't require anything more. And of course, there wasn't any request by any party to make additional findings of fact or conclusions of law. So there is, of course, one finding in the clerk's order about the mother's wishes, but again, it's appellate's burden to demonstrate prejudicial error. So it's not sufficient to simply say the clerk got it wrong in one aspect of her decision making. The prejudicial error would require appellants to demonstrate that the clerk was likely to have reached a different decision. And here, there's no indication in the transcript or in the written order that the clerk would have come out differently. And importantly, that finding question goes to the grief counselor as well. The presumption under the law is that if a judicial fact finder doesn't mention expert testimony, then we presume that it wasn't part of the analysis. It doesn't go the other way, as my friend would have this court believe. The presumption is that it wasn't part of the analysis, and there's no reason to look behind the curtain, and I believe he said, we believe that it mattered, or something to that effect, but that's not how the analysis works. And to the grief counselor, I would disagree with my colleague's characterization of her testimony. I mean, there's no dispute that she was a licensed counselor and had been licensed for 10 years and had specialized training in grief and trauma and was familiar with grief and trauma patients. There was no dispute that she had background in this area and that she had met with the child. And so I believe Mr. Burns said a couple of times that her opinion was based solely on a 20-minute interview with the child, and that's simply not what the record bears out. In fact, the grief counselor testified that her initial meeting was an hour, and part of that, the 20 minutes, was meeting with the child. The rest of it was meeting with Mr. Mann, who was there to assist with the counseling. And of course, by the time the grief counselor was testifying at the hearing, she had met with the child several times. And so her assessment as provided to the clerk was not simply based on a 20-minute interview with the child. And again, so there are several layers of discretion here. The ultimate decision of best interest is a discretionary matter. I believe both sides agree on that. Section 35A-1223 provides a layer of discretion in what evidence to consider. It says the clerk can consider whatever testimony, affidavits, records, etc., that the clerk deems necessary. If the rules of evidence were to apply, which of course we disagree with, the application of those rules is also discretionary. For example, Rule 702, which again, we're not conceding applies to a guardianship hearing, but if it did, would still be discretionary. A Daubert analysis is discretionary, and it's up to the fact finder or the judge to determine whether a witness is qualified and is proffering reliable and relevant testimony. Same with the analysis of prejudicial versus probative. That again is discretionary. And the reason is because the fact finder or the judge in a bench trial is familiar with the parties and the evidence and can make that determination. We defer to that understanding of the relevant facts and issues. If I could just take a step back then, Section 1-301.3 provides the appellate procedure for review of these decisions. It says that the Superior Court's role is to look at the standard we're all familiar with. Are the findings supported by the evidence? Are the conclusions supported by the findings? Is the conclusion consistent with the law? Notably, the appellants haven't really challenged any of that here. The findings are supported by the evidence. The conclusions are supported by the findings, and the ultimate decision was within the clerk's discretion. So for that reason, the Superior Court did, in fact, analyze it correctly. I believe my colleague said that the Superior Court, it's unclear whether the Superior Court used the correct standard of review. But in fact, the Superior Court laid out its review, and as referenced, Judge Hampton on page 99 of the record said, I am determining the findings were supported by the evidence, the conclusions were supported by the findings, the decision was consistent with the law, and there was no prejudicial error in the admission or exclusion of evidence. So the Superior Court understood its role, as did the clerk. Unless the court has further questions, we would ask that this court affirm the Superior Court and maintain the placement of the child with Mr. Mann.
Thank you, Mr. Nelson. Anything further from Judge Hampton or Judge Zachary?
Yes, Your Honor. Oh, sorry.
No, I'm sorry. I was talking basically whether or not there's any other questions for Mr. Nelson. Okay, I see shaking of heads. No, thank you. Now, Mr. Burns, we're back to you, sir.
All right, thank you, Your Honor. Responding to several points made by Mr. Nelson, first and foremost, it's just not the case that the clerk is not required to make findings of fact. 1-301 3D expressly requires that the Superior Court, as an appellate court, determine whether the findings of fact are supported by the evidence, whether the conclusions of law are supported by the findings of fact, and whether the order or judgment is consistent with the conclusions of law and applicable law. So it's clear that the clerk does have a duty to do that, which is reviewed at the Superior Court level. Regarding the abuse of discretion that Mr. Nelson argued for, there's still, to Judge Hampton's point, there still has to be a standard with which we decide whether a discretion was abused. There has to be a framework, and it should be, it is, we contend, the rules of evidence. Regarding the prejudice or lack thereof that Mr. Nelson says that the petitioner's appellants have suffered based on the various evidentiary rulings, I would, and this goes to Judge Zachary's question as well, the clerk, in excluding various things and accepting other things into evidence arbitrarily, has given herself a skewed perspective of the child's mental condition that did manifest itself in inappropriate findings of fact under our contention. The clerk, with regard to how heavily she relied on the grief counselor's testimony, the record is replete with statements made by the clerk that she doesn't want to hear from anybody but the guardian ad litem or the therapist as to what the child is feeling, what the child thinks about his life, and where the child wants to be. Neither the guardian ad litem nor the clerk brought that evidence forward. In particular, they didn't bring forward any statements that the child may have made regarding where the child wants to live. And so to find that he was well-adjusted.
If I can quickly on that point with regard to the guardian ad litem, I guess my question is, well, did anybody ask the guardian ad litem? Did anybody create a record of what the guardian ad litem would have stated these statements?
The guardian ad litem gave her report, and the parties weren't allowed to cross-examine the guardian ad litem about the custody part of it. There were questions asked about the finances, and that issue was followed up on. But to answer your question, no. But ultimately, something that Appellate doesn't address in his brief or in his argument is that Cogdill v. North Carolina State Highway Commission provides that by excluding evidence which is objected to, but which on review the appellate court believes should have been admitted, the decision can be easily reversed, and this one should be in part for that reason. It seems, based on statements made by the clerk, that she had a predetermined view of the parties. And in fact, she says, I know what I'm dealing with here. During the testimony of the first witness, which was Ruby Harkness, the petitioner, she says, I know I'm dealing with all good people, and they all want to be guardians of this child. And then consistently made evidentiary rulings excluding statements that were made by the child to others that would undermine that predetermined belief. And so that the skewed view that she has could not possibly have resulted in an appropriate final guardianship award that complies with her obligations to admit and consider all relevant evidence, as is also the case with best interest of the child cases, and to not commit prejudicial error in excluding or admitting evidence in order to make her consideration. But ultimately, she doesn't, at the end of the day, give any justification for giving guardianship to Mr. Mann over the petitioners in her ruling, and therefore we would ask this court to vacate the Superior Court's order.
Thank you, Mr. Burns.
Thank you, Your Honor.
We appreciate the involvement today of you, Mr. Burns, and also Mr. Nelson, and we thank you for being with us.
Thank you.
Thank you. Mr. Clerk, would you please adjourn our court?
This session of the North Carolina Court of Appeals is now adjourned.
Thank you both. Have a good day.